The letters were stacked in a shoebox on the top shelf of my hall closet, 41 of them, each one in its original envelope with the postmark intact. And for 3 years I had left them exactly there, not because I was sentimental about them, but because something in me understood, even in the early months when I still believed the whole affair might resolve itself quietly, that a document kept is a weapon held in reserve. The August heat was already pressing through the walls of the house on Delwood Court when Gareth Hollis, 32 years old, and the owner of record for the property at 14 Delwood Court, since the estate of his late uncle had transferred the deed 4 years prior, stepped out onto the front driveway at 7 in the morning and found a notice taped to the mailbox post. He read it once, then again, and then he went inside, put on a second pot of coffee, and retrieved the shoebox from the top shelf. The notice informed him that the Delwood Commons Homeowners Association had voted, at a meeting he had not been invited to attend, to classify the eastern side fence along his property line as a community encroachment, and that he had 14 days to remove it at his own expense, or the association would arrange removal and charge the cost to a lien against the deed. The notice was signed by the board representative, whose name was printed in a clean serif font beneath a neat official signature, Cornelia Voss, Director of Community Standards, Delwood Commons HOA. He did not know yet that Cornelia Voss had been sending letters to the neighbors along Delwood Court for 6 months before this particular morning. Letters that characterized his fence, his roof overhang, his driveway apron, and his detached garage as ongoing violations of the community aesthetic standards. Letters that urged other residents to sign a petition and request emergency board authority to act without the standard review period. He did not know that she had already secured that authority. What she did not know, and had not bothered to learn, was that Gareth Hollis had spent 11 years as a licensed property surveyor before leaving the profession to manage the estate his uncle had left him, and that the shoebox on the top shelf of his hall closet was not the only archive he kept. Stay with this story to the end, because the document Cornelia Voss was most proud of turns out to be the one that undoes everything she built. The house at 14 Delwood Court had come to Gareth not as a windfall but as a responsibility, and he had treated it that way from the first week of ownership. His uncle, Theodore Hollis, had lived in the house for 26 years before his death, and Theodore had been, by every account of the long-time residents who remembered him, a quiet and precise man who kept his property the way a craftsman keeps his tools, in order, in good repair, and exactly where they were supposed to be. The eastern fence had been installed by Theodore in the spring of 1998, set at the surveyed boundary line and permitted by the county under a permit that Theodore had filed in triplicate and stored in a hanging file folder in the second drawer of his oak desk. That folder was one of the first things Gareth had found when he cleared the study after the funeral, and he had read its contents with the professional attention of someone who had spent more than a decade reading survey documents for a living. The permit listed the boundary coordinates. The coordinates matched the county plat. The fence was legal, correctly placed, and had been continuously maintained for 26 years before Cornelia Voss decided it was not. The driveway apron, a poured concrete extension that ran from the garage door to the street curb, had been added by Theodore in 2007 under a separate permit, also filed, also stored in the same oak desk. The garage itself, detached and standing at the rear of the lot, had been built in 2001, permitted, inspected, and signed off by the county building department under a certificate of occupancy that Theodore had framed and hung on the interior wall of the garage, where it remained. The roof overhang that Cornelia's letters described as an encroachment over the shared walkway easement was, in the county's recorded easement document, expressly excluded from the definition of encroachment because it had existed prior to the easement's formalization in 2004. Gareth knew all of this. He had verified it within the first month of taking ownership. partly out of professional habit and partly because his uncle had told him once, in a conversation Gareth had not fully understood at the time, that the one thing a property owner must never be is uninformed about what he owns. He had thought about that sentence many times since the first letter from Cornelia Voss arrived, 14 months before the notice on the mailbox. A letter that politely but unmistakably suggested he consider voluntarily relocating the fence to accommodate what she described as the association's long-term landscaping vision for the eastern corridor. He had replied in writing by certified mail, enclosing a copy of the 1998 permit and a copy of the current survey plat with the fence line highlighted, and he had explained plainly that the fence was correctly placed and that he would not be moving it. Cornelia Voss had not replied to that letter. She had instead sent 3 more letters over the following 4 months, each one less polite than the last, each one citing a different section of the association's community standards document, and each one suggesting that his continued refusal to cooperate was damaging the community's property values and his own standing as a neighbor. He had kept every one of them in their original envelopes and had drafted a careful written response to each, sent by certified mail, enclosing the relevant permit or document each time. None of those responses had generated a reply from Cornelia Voss either, but the certified mail receipts showed they had been received, and Gareth had filed those receipts in the same folder as the copies of his letters. The first time Gareth saw Cornelia Voss in person was at the community meeting she called in late October, 2.5 years into his ownership of the property, and roughly 10 months before the notice appeared on the mailbox. She arrived at the community room of the neighborhood's shared amenity building in a red blazer over a white shirt, her blonde hair pinned up with a precision that matched the organization of her printed agenda, and she moved through the assembled neighbors with the ease of someone who had been the central authority in that room for a long time. She was somewhere in her mid-40s, Gareth estimated, and she had the particular confidence of a person who had never been seriously contested. He sat near the back of the room with a legal pad and a pen, and he said nothing during the first 40 minutes of the meeting, while Cornelia presented what she called a comprehensive review of community standards compliance across the Delwood Court properties. His property appeared on the list with 4 violations cited: the eastern fence, the driveway apron, the garage footprint, and the roof overhang. The citations each referenced a specific article of the community standards document, and each one was accompanied by a photograph that Cornelia, or someone acting on her behalf, had taken from outside the property line. When the floor opened, Gareth raised his hand. He told her, unhurried, that he had reviewed each of the cited provisions and could provide documentation showing that each of the 4 features she had listed was either permitted by the county, predated the community standards provision she was citing, or fell within an explicit exemption in the easement language. Cornelia told him that documentation from 25 years ago was not necessarily relevant to current standards. He replied simply that county permits and recorded plat boundaries did not expire. She told him the board would take his comments under advisement. The meeting ended. She did not look at him as the room cleared. 3 weeks later, the 4th letter arrived, this one considerably more formal than its predecessors, citing the board's authority under the community standards bylaws to schedule inspections and assess compliance findings. The 5th letter arrived 2 weeks after that, and it enclosed a bill for an inspection fee that no Inspector Gareth could identify had ever conducted on his property. He photographed both letters on the day they arrived, including the envelopes, and sent certified written responses to both within 48 hours, enclosing in the response to the inspection fee letter a written request for the name, license number, and inspection report of the inspector who had allegedly conducted the assessment. No response came. The receipt showing the letter had been delivered sat in the folder with the rest. The escalation that followed was not subtle, but it was patient, the way a flood is patient, rising by increments that each feel manageable until the room is full. By December, Cornelia Voss had circulated a second letter to the neighborhood, this one addressed to all residents of Delwood Court, rather than to Gareth alone, and it described what she called an ongoing compliance dispute with a property owner who had declined to cooperate with reasonable community improvement requests. She did not name him, but the description of the disputed features made identification trivially easy for anyone paying attention. Two neighbors whom Gareth had considered friendly acquaintances stopped returning his greetings when he passed them on the street, and a third told him directly, though with some awkwardness, that Cornelia had explained the situation at a separate meeting Gareth had not been invited to, and that most people felt he was being difficult about a small thing. He thanked her for telling him and went home and wrote down the date and the substance of the conversation in the running log he had been keeping since the second letter. By January, Cornelia had submitted what she described as a formal compliance complaint to the county planning office, alleging that the eastern fence was a code violation. The county planning office reviewed the complaint, pulled the permit on file, and sent a response to both Cornelia and, as a courtesy copy, to the property owner, stating that the fence had been installed under a valid permit and was not in violation of any county code. Gareth received his copy on a Tuesday morning and filed it without particular satisfaction, because he had expected nothing less, but also with the understanding that the county's written finding was now part of the record, and that Cornelia Voss had generated it herself by filing the complaint. The 6th and 7th letters arrived in February, both of them shifting their tone from procedural to legalistic, citing association authority to pursue remediation through the county civil court system if the property owner continued to refuse voluntary compliance. He read them carefully, made copies, filed the originals, and drafted responses, citing the county planning office's finding and asking Cornelia to identify, in writing, the specific legal basis under which the association claimed authority to override a valid county permit. No response came. He had begun to understand by this point that the absence of a response was itself informative, because an association with genuine legal authority to do what Cornelia claimed would have had a lawyer's letter in his mailbox long before February, and that no such letter had arrived suggested either that the authority she claimed did not exist, or that whoever she had consulted had told her something she was not prepared to share. He did not share this analysis with anyone yet. He photographed the February letters, filed the originals, and waited. Cornelia Voss, for her part, sent 3 more letters before the summer, each one shorter and less legally specific than the last, each one leaning harder on the language of community disappointment and neighbor harmony, and each one arriving within 48 hours of a certified mail receipt confirming delivery of his previous response. He kept every one. The thing that changed the geometry of the whole dispute arrived not from a lawyer or a county office, but from a woman named Patricia Odom, 61 years old, who had lived at 9 Delwood Court for 18 years, and who appeared at Gareth's door on a Wednesday evening in April, carrying a manila envelope. Patricia had been on the HOA board herself for 4 years in the early period of Cornelia Voss's directorship, had resigned over what she described at the time only as a difference of philosophy, and had kept, in the intervening years, copies of certain board meeting minutes and financial records that she had taken with her when she left. She had been watching the situation on the street, she told him, and she wanted him to see something. She sat at the kitchen table and laid out 12 pages of photocopied board meeting minutes from a period 3 years earlier, and she pointed to a resolution that the board had passed at a meeting where only 3 of the 5 board members were present. The resolution granted Cornelia Voss, in her capacity as Director of Community Standards, the unilateral authority to assess compliance findings and initiate remediation proceedings without the full board vote that the association's own governing documents required for any action involving a potential lien on a property deed. The resolution, Patricia explained quietly, had been passed with 2 votes, Cornelia's own and that of a board member named Douglas Fain, who happened to own a landscaping company that had received the association's maintenance contract for the past 3 years, a contract awarded in a closed session with no competitive bidding. She also showed him a copy of the community standards document that Cornelia had been citing in her letters, the version currently posted on the association's website, and she placed beside it an earlier version of the same document, one she had kept from her time on the board. The two versions were not identical. In the current version, the language establishing a grandfather exemption for structures permitted and built before the association's formal founding had been removed. In the version Patricia had carried out of the building 3 years ago, that language was present and unambiguous, and under it, every feature of 14 Delwood Court that Cornelia Voss had cited as a violation was explicitly exempt. The amendment removing the grandfather language had never been put to a community vote. It had appeared in the published document without any notice to the residents and without the ratification process the association's own bylaws required. Patricia told him she had been sitting on this for 3 years because she had not had a reason strong enough to act on it and had not been certain anyone would listen. Gareth thanked her plainly and asked if she would be willing to provide a written statement to that effect and make the originals of the documents available for review. She said she would. He asked whether she knew how many other properties on Delwood Court had received compliance letters under the amended standards. She told him she thought it was at least 6, possibly 8, and that 2 of those residents had already paid fines assessed by Cornelia under the enforcement authority the board had granted her in the resolution that had never been properly passed. He wrote down both of those things in the log. That evening he called Marcus Sheedy, a property law attorney he had worked with during his surveying years, and explained what he had. Marcus listened without interrupting, asked 4 questions, and told him to gather the originals and come in at 9 the next morning. The morning that changed everything publicly rather than privately was the first day of August, which arrived after 3 weeks of preparation that Gareth and Marcus had conducted with a deliberateness that left no step undocumented. Marcus had filed a petition with the county civil court requesting an emergency injunction against any further lien proceedings against 14 Delwood Court, attaching to the petition the county planning office's compliance finding, the original permit documents, the survey plat, the 2 versions of the community standards document with the deleted grandfather language highlighted, the board resolution that had granted Cornelia her unilateral authority, and sworn statements from Patricia Odom and from both of the residents who had paid fines under that authority. The court had granted a temporary restraining order within 48 hours and scheduled a hearing for the first week of September. What happened on the first day of August was separate, and Gareth had not planned it, but it arrived with the inevitability of something that had been building for a long time under pressure. He was on the driveway at 7:30 in the morning, as he usually was, when Cornelia Voss arrived in her white sedan, with a man he recognized as Douglas Fain, driving a second vehicle, a flatbed truck, and 2 workers in the truck bed with post-hole diggers. She walked to the property line and announced, loudly enough for the 2 neighbors across the street who were retrieving newspapers to hear, that the association was exercising its remediation authority to remove the non-compliant fence. Gareth raised his phone and began recording. He told her plainly that a restraining order was in effect and that he had a copy for her in the house. She told him the association had not been properly served. He walked inside, retrieved the stamped copy of the restraining order, returned to the driveway, and held it at arm's length so that both the document and her response to it were captured by the phone's camera. She said the workers would wait while she reviewed it. Douglas Fain read it over her shoulder. The flatbed truck sat idling at the curb for 11 minutes, and then Fain said something to her in a low voice, and the workers climbed back into the truck bed, and the truck pulled away. Cornelia Voss stood at the edge of the property line for a moment longer, and then she returned to her sedan without speaking, and Gareth uploaded the video to a time-stamped cloud folder while he was still standing in the driveway. 3 neighbors watched all of this from the street. By that afternoon, the story was moving through the neighborhood in the way that things move through a small community when a certainty is cracked. Because the neighbors who had watched Cornelia Voss operate for years with the confidence of someone who had never been stopped were now watching her drive away from a piece of paper, and the distance between what she had told them and what they were now seeing was becoming impossible to close. The September hearing lasted 2 days, and the court heard testimony from Patricia Odom, from both residents who had paid fines, from Marcus Sheedy on the survey and permit record, and from a forensic document analyst Marcus had retained who testified that the current version of the community standards document showed signs of having been altered digitally from the earlier version, with the grandfather exemption language removed and the document's metadata adjusted, though not adjusted sufficiently to prevent a competent analyst from identifying the discrepancy. Cornelia Voss testified that the amendment had been duly approved and that the records of that approval existed. When Marcus asked her to produce those records, she provided a set of meeting minutes that the forensic analyst had not yet seen. The analyst was recalled the following morning and testified that the minutes Cornelia had produced showed signs of the same alteration pattern as the standards document. Douglas Fain, who had been served with a separate civil complaint 2 days before the hearing, did not appear. His attorney submitted a written statement on his behalf, and the statement, under questioning from the judge, resolved into an acknowledgement that the landscaping contract had been awarded without competitive bidding, and that Fain had voted in favor of the resolution granting Cornelia her unilateral enforcement authority in exchange for the contract. The judge voided the enforcement authority resolution on the grounds that it had not met the quorum or ratification requirements of the association's own governing documents. She voided the compliance findings against 14 Delwood Court in their entirety. She ordered the association to refund the fines paid by the 2 other residents, with interest. She referred the question of the altered documents to the county prosecutor's office for review. She also appointed a neutral administrator to oversee the association's operations and conduct a full audit of its financial records and governance history for the preceding 5 years. Cornelia Voss was removed from her position as Director of Community Standards as an immediate condition of the court's remediation order, and the terms of her removal prohibited her from holding any governance role in a homeowners association in the county for 10 years. She did not speak to any of the neighbors on Delwood Court as she left the courthouse. Douglas Fain terminated his landscaping company's county operations and relocated his registration to a neighboring county within 3 weeks of the hearing's conclusion, though the civil complaint against him remained active. The neutral administrator's audit, completed 4 months after the hearing, identified 11 additional residents who had paid fines or fees under the voided enforcement authority, and each of those refunds was processed with interest by the end of the calendar year. The fence at 14 Delwood Court stands where it has always stood, at the surveyed boundary line, in the same position Theodore Hollis set it in the spring of 1998. And if you measure it with a transit and a plumb line, which Gareth did, one Sunday in October after the leaves had turned and the legal proceedings had settled into their final administrative phase, it is within 2 inches of the coordinates recorded on the original permit. The driveway apron is unchanged. The garage stands at the rear of the lot under its framed certificate of occupancy. The roof overhang casts the same shadow it has always cast over the walkway that was always, under the easement language that was always in the record, expressly allowed to receive it. Patricia Odom, who had carried her manila envelope to Gareth's door on a Wednesday evening and changed the shape of the next several months, was elected to the reconstituted board in the spring that followed the hearing, alongside 4 other Delwood Court residents who had watched the audit's findings and decided that governance was something worth taking seriously. She declined the directorship of Community Standards but accepted a seat on the Finance Committee, and she told Gareth, when they spoke at the first open meeting of the new board, that she had kept those documents for 3 years because her uncle had once told her that a record kept was a door that could always be opened. He thought about Theodore then, and about the hanging file folder in the second drawer of the oak desk, and about the way the people who build careful records rarely know, at the time of building them, which door those records will one day open. The two residents who had paid fines got their money back in November and December respectively, and each of them made a point of telling Gareth that they wished they had listened more carefully when he had tried to explain the situation 18 months earlier. He told both of them, without blame, that the explanation had not yet had the facts behind it that it later acquired, and that the facts were the thing that mattered. The shoebox is still on the top shelf of the hall closet. He considered doing something deliberate with it, framing the first letter or burning the last one in some gesture that would mark the end of the affair. But in the end, he left it where it was, because the habit of keeping things is not so easily set aside, and because what the box contains is not a record of grievance but a record of patience, and patience is not the kind of thing you commemorate, it is the kind of thing you continue. Power that cannot produce its paperwork is not authority. It is only confidence, and confidence, held up against a document, is the first thing to go. The audit itself had taken longer than the court expected, and the neutral administrator, a retired county records supervisor named Howard Crane, had approached the association's filing cabinets with the methodical patience of a man who understood that disorder in a document is almost never accidental. What he found, over the course of 4 months of careful work in the association's storage room, was a pattern that began well before Cornelia Voss had ever sent a letter to 14 Delwood Court. The earliest irregularity he identified dated to 6 years prior, when the association's reserve fund, maintained for the repair and upkeep of shared amenities, had been drawn down by $11,000 through a series of small disbursements that the meeting minutes for that period recorded as routine maintenance expenses, but for which no corresponding invoices existed in the files. The invoices that did exist, Howard found after cross-referencing the association's bank statements with the vendor records Patricia Odom had retained, corresponded to work orders submitted by Fain's Landscaping Company for services that several residents, when interviewed, said they had never observed being performed. The administrator documented all of this with the same flat thoroughness he brought to everything else, and his final report ran to 61 pages with 43 exhibits, and when Marcus Sheedy read it on the morning it was released, he called Gareth and told him, in a tone that was careful rather than excited, that the report had been forwarded in its entirety to the county prosecutor's office, and that the original referral from the September hearing had now expanded into something considerably larger than an altered document. Gareth asked what that meant practically, and Marcus told him it meant that the matter was no longer a civil dispute between a property owner and a homeowners association, but a criminal investigation into the management of funds that did not belong to either of them. He thanked Marcus and hung up and stood in the kitchen for a moment, looking through the window at the fence along the eastern property line, and then he went back to the work he had been doing. The county prosecutor's office completed its review the following spring and filed charges against Cornelia Voss on 3 counts: document falsification, breach of fiduciary duty in her capacity as a board officer, and misappropriation of association funds. The charges against Douglas Fain, processed through a separate filing in the county where he had relocated, included the same misappropriation count and an additional count related to the submission of fraudulent invoices. Both defendants entered not guilty pleas, and the cases were scheduled for trial, though Fain's attorney initiated plea discussions within 6 weeks of the filing, and an agreement was reached before the summer in which Fain admitted to the invoice fraud, agreed to restitution of the full amount identified in the audit, and received a suspended sentence conditioned on 5 years of supervised probation and a permanent bar from any contract work with public or quasi-public bodies in the state. Cornelia Voss did not seek a plea agreement. Her case proceeded to a bench trial in the autumn, 14 months after the September hearing at which the civil judge had first voided her authority and the prosecution presented the altered documents, the forensic analysis, the administrator's report, and the testimony of 11 residents who had paid fines or fees under the authority she had manufactured. She testified in her own defense that she had acted in good conscience and in the best interests of the community, and that the alterations to the standards document had been made in consultation with legal counsel, though she could not produce any documentation of that consultation, and no attorney came forward to corroborate it. The judge found her guilty on the falsification and breach of fiduciary counts, and acquitted her on the misappropriation count, finding that the evidence connecting her directly to the fund disbursements was insufficient without Fain's testimony, which his plea agreement had rendered unavailable. She was sentenced to 18 months of supervised probation, ordered to pay restitution of $4,200 representing the administrative costs of the audit and the court-appointed administrator, and fined an additional $2,000. She left the courthouse in the same red blazer she had worn to every public proceeding, and Gareth, who had attended the sentencing with Marcus and Patricia, watched her go without any particular feeling, except the mild and sober recognition that the proceeding had done what it was designed to do, and that no additional sentiment was required of him. The reconstituted board amended the community standards document at its first properly noticed public meeting, restoring the grandfather exemption language in full and adding a provision requiring any future amendment to be ratified by a 2/3 vote of all dues-paying members rather than a simple board majority. Patricia moved the amendment from the floor. It passed without dissent. The board also adopted a new procurement policy, requiring competitive bidding for any contract exceeding $500, and a 2-board member review for any disbursement from the reserve fund, and it published both policies in full on the association's website, alongside the administrator's final report, which the new board had decided to leave publicly accessible as a record, rather than archive it. Marcus told Gareth, when they reviewed the new documents together, that the governing structure the board had now adopted was more rigorous than most associations of twice the size, and that whoever had drafted the amendment language had done careful work. Gareth told him that Patricia had written the first draft and that he had reviewed it and suggested 3 changes, all of which she had accepted. Marcus said that was probably the most useful thing either of them could have done. There were smaller resolutions that autumn and winter, that the formal record did not capture, but that mattered nonetheless. The neighbor who had told Gareth directly that most people felt he was being difficult brought him a jar of preserves from her kitchen in October and stood on the driveway for 20 minutes talking about her garden, and neither of them mentioned the conversation from 18 months prior, because it did not need to be mentioned, and because the acknowledgement implicit in standing on someone's driveway with a jar of something you made yourself is more complete than any explicit apology. 2 other residents who had signed the petition Cornelia had circulated in the early months of the dispute stopped him separately on the street and said things that were approximate to sorry, without quite being that word, and he received each of those conversations with the same unhurried steadiness with which he had received every other thing in the preceding 3 years. He did not tell any of them that he had been certain of the outcome from the moment he read the documents in Theodore's filing cabinet, because that would have been both unkind and inaccurate. He had not been certain. He had been prepared, and the 2 things are different, because certainty is a feeling and preparation is a practice. And what the practice had produced, over 3 years of letters sent and filed and receipts collected and logs maintained, was not a guaranteed outcome but a documented one, and a documented outcome, when it arrives, is the only kind that holds. Howard Crane, the administrator, retired fully in the spring following the conclusion of his audit work, and he sent Gareth a brief handwritten note before he did, which said only that in 30 years of reviewing records he had found that the quality of an individual's personal archive almost always predicted the quality of the outcome they eventually received, and that he meant this as a professional observation rather than a compliment, though it could be taken as both. Gareth read the note twice and put it in the shoebox with the 41 letters. It was the 42nd item in the box, and he did not add a 43rd, because by then there was nothing left to keep. The fence stood. The permit was in the drawer. The audit was on the website for anyone who wanted to read it, and several people did, including a resident from a neighboring development who wrote to the new board, asking whether they would be willing to share their amended governance documents as a template, which the board agreed to do at its next meeting, and copies went out to 3 other associations in the county over the course of the following year. Patricia mentioned this to Gareth at the spring block gathering. The first one Delwood Court had held in 4 years, standing in the afternoon light with a paper cup of lemonade and a quiet satisfaction that did not need to be named aloud. He said it was a reasonable thing to do with a document that had cost everyone enough already. She agreed that it was. The afternoon settled around them the way afternoons do when the thing that was wrong has been made right, and there is nothing left to argue about. And the street was quiet, and the fence along the eastern side of 14 Delwood Court stood where it had always stood, and where it would continue to stand, because some things are exactly where they belong, and the only question was always whether anyone had kept the paperwork to prove it.